Great to come back and have an opportunity to give folks an update on LawPro. I think sometimes the last slot before lunch is not the best one because people are thinking of lunch and heading home. But at this conference, given I suspect there were a few bodies up late last night in the hospitality suite, slightly later in the morning may be a good thing. So I'll take it that way. On my agenda today, I'm going to give you a general LawPro update, but in my year and 3/4 or so far as CEO, as one of the perspectives I've gained is that there's some misimpressions, even misinformation or fake news in the current lingo out there at LawPro. So I kind of wanted to take the opportunity to correct some of those misperceptions. So I'm going to talk about, going right back to day one, why LawPro is different from other insurance companies, a bit of a LawPro 101, where and why we're here. I'm going to update you on the 2020 program changes, talk about LawPro myths and fake news, a brief update on some of the claims trends we're seeing, then going to ask you for some help and happy to take questions at the end. So, why is LawPro different from other insurance companies? And we're actually quite different. First of all, we have to insure every lawyer in private practice. We can't say no to folks if they're in good standing and apply. We have to insure them, including the repeat offenders, unfortunately. Because we insure everyone, it's in our interest, and frankly it's in your interest as well, to work to reduce claims, and we do that through Practice Pro. I'll talk more about that. We do not look for ways to deny coverage. If there is an allegation of negligence in a claim or a situation or circumstances of claims involving negligence, we will step up to the plate and defend the lawyer. We will appoint repair counsel to fix mistakes and reduce damages. I'm going to talk more about that. We take a principled approach to settling claims. If we look at the claim and there's a clear error by the client and damages suffered by that client, we'll step up to the plate, we'll try to effect a repair to reduce damages, but we will try to get to a reasonable settlement. On the other hand, we will vigorously defend a claim where there is no negligence or damages suffered by a client. We do not make economic settlements, and that's very important for us because we want to control and shape the law of lawyers' negligence. And lastly, we work collaboratively with our defense counsel and with the insured to come to a resolution of a claim. We don't do litigation in-house. We have an excellent group of outside defense counsel with expertise in the different specific areas of law, as well as lawyers' negligence within those areas of law that help us out. So, why LawPro? The basic, simple reason is public protection. Someone to stand behind lawyers in the event that their lawyer makes a mistake. And the Law Society Act contemplates the Law Society having a mandatory universal insurance program. We have had mandatory insurance in Canada since the early 70s. All of the different law societies have an insurance program. They are set up in slightly different ways across the country, but in many ways they are very, very similar. Our policies are not identical, but they're very similar. Excepting Quebec, the limits under the policies are the same, $1 million per claim, $2 million in the aggregate across the country. That has allowed us to have mobility. That is, you can move to another province on a temporary basis and do work in many different areas of law, and that's a remarkable thing. It took many years to get that, but that universality of coverage, similarity of coverage, allows that to happen. What is LawPro? We are a FSRA-regulated insurance company. We are wholly owned by the Law Society, and we're licensed by our regulator, by FSRA, to provide professional liability insurance in Ontario. So that's a narrow coverage. It's coverage for the work that lawyers do with their legal hat on. It was launched, I know there's a few gray hairs in the room and will remember this, LawPro, formerly LPIC as it was launched back in 1995 in response to the insurance crisis. And for those that don't have gray hair in the room, the insurance crisis was a situation that arose after the real estate market crashed in the early 90s, and it left the Law Society insurance program with a major crisis. It had $200 million plus in unfunded liability claims. So a mandate was given to a task force of the Law Society to look at the options, and the options were get out of insurance completely and leave it open to the open market, or come in and have a mandatory captive provider. And that was the mandate that was accepted and approved by Convocation, and 25 years later, that's our marching orders every single day of the year still. We are set up to operate independently from the Law Society. We have our own board of directors. There are 4 benchers on our board. The other directors, majority of directors, are independent directors, and we have people on our board with expertise in insurance and investments, auditing, technology, and so on. We are mandated to operate in a commercially reasonable manner. That means the money coming in has to match or pay for the money going out. Money coming in premiums has to pay for the claims and the operating expenses of the company. Now, on $100-odd million of premium in a typical year, we typically budget for a slight profit on the order of a few $100,000, $1 million and change dollars. We have to budget a profit to keep the regulator happy. But for all intents and purposes, we're a not-for-profit insurance company. Premiums should reflect the risk of claims. Not everyone is the same risk, and it's to be fair to everyone, the premiums that you pay should reflect your risk. And I'm going to talk in a number of ways about how we do it. We were also mandated to deal with claims fairly and expeditiously, and that's where we strive to find coverage wherever possible, but we're not a no-fault program. If the claim is a fee dispute or some other unhappy situation between the lawyer and the client that doesn't involve negligence and many different frauds, we don't step up to the plate to cover those. The frauds, many types of frauds go over to the compensation fund. And we were explicitly mandated to deny or limit coverage in appropriate circumstances, and that's to operate in a commercially reasonable manner. So, very quick summary of the mandatory program, and in some ways I hesitate to go over this because everyone should know it, but from the questions we get, there's information here that we know people maybe have forgotten or have overlooked. So on the mandatory, what we call the primary insurance program, I'll talk about our excess program in a second, we insure the lawyers, in round numbers 27,800 currently, and those licensed paralegals that are partners in law firms as well. We want all the partners under the same policy. So there's in round numbers just over 50 paralegals that we insure under our program. The rest of the licensed paralegals in Ontario get their insurance from a commercial provider. We cover professional services. There's a lengthy definition in the policy on that, but basically it's the work you do with your legal hat on, to put that in a simple way. On the LawPro policy, the individual lawyer is the insured, not the law firm. Okay? The individual lawyer is the insured, and that's why we look to and try to deal with the lawyer who was the person responsible on the file where there is a claim. $1 million per year per claim limit and $2 million in the aggregate, regardless of the number of claims. Base premium right now, $2,950, and the default deductible is $5,000. And most sols and smalls go with that. I'll talk about the deductibles. So I could do an hour on our policy. Obviously, don't have time to do that. Please visit lawpro.ca if you want to see a copy, and there are extensive FAQs on the policy there if you've got more questions. Call up our customer service reps if you've got another question. How risk rating is accomplished. The risk rating concept is how we keep the insurance fair. We do that a number of different ways. I'm going to go through each of these in more detail. The premium reductions, transaction levies, different deductibles, the claim surcharge levies, what we call a real estate practice coverage option or REPCO. If you are doing real estate work that is touching title, we run what we call the REPCO coverage. It's mandatory. It was set up at the request of the government to protect against frauds on the title system and some optional coverages. Let me run through each of those in more detail. We have a number of base premium reductions. Thousands of lawyers take advantage of these, and again, behind these are actuarial analysis. Actually, we give these deductions because these people are lower risks. Part-time lawyers, there's a billable hour and gross billings fee. They get a 50% reduction on the base premium. Like fashion, lawyers that practice solely criminal or immigration, new calls are a much better risk. They tend to do smaller things, or maybe they're more likely to ask questions, but historically, in the long term, they have fewer claims early on in those early years, so we give them a 50, 40, 30, 20% discount, respectively, over their first 4 years in practice. And then designated government agencies, think some of the government-run legal clinics, and more recently, the civil society organizations, they get a 75% reduction. And pro bono work. A number of different scenarios for pro bono work to fall under coverage or not under our policy, but in many cases it does. There's extensive information on our website that will give you more details on that if you've got questions, or call up our customer service folks. Transaction levies risk rate for different practice volumes. A real estate practitioner who does 20 real estate deals a year is a very different risk for one that does 200 deals a year. So what we do is we have our $65 real estate transaction. Like fashion for litigation, it's $100 per matter. Of the roughly $100 million we collect a year, about $30 million comes from our transaction levies. And when we look at the kind of primary and secondary and so on areas of practice by lawyers, the money we collect coming in from people who say they do all or some real estate work in levies and premiums roughly equals the money going out. We do our best to do that calculation based on the information we get from the annual report you file with the Law Society, as well as information on our insurance. So that's how we keep it fair for different practice volumes. The different deductibles, $5,000 is kind of the default deductible. Many firms have that. There's a 0, a $10,000, and a $25,000 deductible. The large firms tend to go with the $25,000 deductible. It has a marginal impact on your premium, always, as you would expect for other types of insurance. Conflicts of interest, we actually have a double deductible, and that's a reflection of the fact that in our experience, conflicts claims proportionally are much more expensive than other claims. They often typically involve two parties. They're more complex. So we have a double deductible there, and a $10,000 deductible for certain types of administrative dismissal claims, basically, and I'll talk more about those in a second, but if it was a situation where kind of you went off and did self-help that made the matter worse, we're going to hit you with that extra deductible as opposed to coming to us to help get our help in mopping up the problem. Those that have claims, reflecting a greater risk here, and our experience shows once you've had one claim, you're more likely to have further claims. To make it fair, one claim means a claim surcharge levy of an extra $2,500 over 5 years. 2 claims, an extra $5,000 over 2 years, and so on. So the more claims you've had, that we've had a payment, you have this additional claim surcharge levy. At one point, we had a personal injury lawyer who was running a factory who was paying us $250,000 a year in premium. So just the cost of doing business, I guess, wasn't a good situation. All right, update on our 2020 insurance program. Everybody will be pleased to know the premium is the same again, $2,950, and we set the premium every year by looking at the volume of claims and the cost of claims and kind of development on prior year's claims and so on. So premium stays the same. I know that's always received with a positive feeling. Just a little bit of perspective. In 1995 dollars, that premium would be $1,835. So I think a nice compliment to the effort that we've made to keep expenses down. And again, some of the folks that have been around a bit longer in the room will remember back in 1994, the premium was $5,600 a year. We clarified the circumstances this year in the policy in which a notice of claim must be provided, and again, some technical language there, but basically the bottom line is if you see or think or feel or it's suggested to you by a client that there's a claim there, you need to report to LawPro. We also refined the definitions of spouse. We made it consistent with the family law legislation and the definition of dishonest under the policy, just for kind of clarity purposes there. I want to now turn to some of the most common, I'll call it LawPro policy myths and fake news. So only bad lawyers have claims against them. Of course, that's not the case. Even the best lawyers make mistakes. Sometimes the ball bounces in a direction you didn't anticipate, unanticipated circumstances come up, and so on. And that's why it's great to have an insurance program standing behind you for both the client and you as well. Our statistics show that 42% of the lawyers in private practice currently have had at least one LawPro claim. Next up, lawyers only need to report to LawPro when they get a statement of defense. I'm going to say, hello, folks. This actually happens, believe it or not. Or we get a phone call at 9 o'clock in the morning saying, oh, I have examinations for discovery commencing at 10 o'clock. Can I ask somebody about what I should say today? Or I'm in court on a summary judgment motion at 10 o'clock. Can I get some help today? That happens, and it happens far too often. So please report a claim if you discover you've made a mistake. If a client has made an allegation of mistake, even if it's bogus, call us up. When you're asked to produce a file, before you produce it, please call it. Or if there's a court order ordering that you produce your file. In those last two cases, we will talk you through the circumstances, give you some advice on what you should say or do. In the case of going to an examination for discovery or attending at court, if we see an opportunity for a repair or for a loss prevention, I'm going to talk about the distinction there, we will actually send one of our defense counsel along to help out and hold your hand there. When in doubt, please report. People may report and give us the circumstances. We may say to you, thanks, we don't see any problem here. We won't even be opening a file, or we may just open a file and kind of keep it open, and at least we've been put on notice and let it kind of go on. If lawyers can fix their own mistake, they should try to do that before contacting LawPro. We see too much DIY repair work, unfortunately. Never try to fix a mistake, and even if you are really experienced in your particular area of law, you're in the middle of it, you may not see all the things that you can do. Don't admit to a client that you've made a mistake. We will contact us, we'll talk you through what you should say, what you should do. Keep in mind that if you try to effect a repair or fix your mistake or ignore your mistake, and ultimately that's to the prejudice of LawPro in terms of taking steps to deal with that claim. If more damages are caused there, we may take an off-coverage position with respect to covering you when it finally comes to our attention. Don't just let the firm handle the claim. And more senior people here, typically we see this sometimes more with associates. Again, going back to the fact that the individual is the named insured under the policy. We look to see who was properly responsible for the file and the error that occurred on the file. And we sometimes see difference of opinions on that, junior, senior lawyer. Frankly, the associate that left last month seems to get a lot of claims directed their way. But we're going to ask questions, and we're going to find out truly who was responsible. If the associate was truly running with the file, then we're going to come after and think that they should be the responsible lawyer and the one that we deal with on the claim, that the deductible, we will look to them to pay the deductible. If it's really the senior partner who was pulling the strings and running the file, then we will look to them in terms of saying, no, the claim is really with you. And when there are differences of opinion on that, we try to sort those out. There's actually an arbitration process we sometimes resort to that's provided for in the policy to deal with that situation. And ultimately, under the policy, if the deductible is not paid by the person who we think was responsible, we can actually look to the partners of the lawyer at the time that the claim happened. Question here.
I was told, now granted this was 10 years ago, by a LawPro lawyer, so somebody who does your defense work, still does, that the claim is open under the name of the person who calls to report the claim. So you're an associate, you're told to report the matter to LawPro. And then is that true, number one? Still, may not be. And so then the worry is that even though in the end it all may be sorted out as you've explained, that's still, when people go to look for a claim, that's still there against the person that actually reported it to LawPro.
Okay.
Repeat the question, sorry.
Sure. So the question is, if someone phones up to report a claim, potential claim, junior associate, because they're told, call up and report this claim, is the file opened in their name? It depends. Often in the situation where there's some monkey business going on, we may not get all of the facts. If it does come in and we do open it in that particular individual's name, but it's then transferred to another's lawyer as being the responsible lawyer, then I believe the file would be switched over. There wouldn't be something kind of remaining there. Okay? No notes means there's no evidence that I made a mistake. Okay. No notes, frankly, makes it harder to defend, and not when there are notes are they often truly helpful. But please remember, clients are going to remember everything. Okay? He had a white shirt and a paisley tie, and he said blah, 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 blah. Well, what did you say? I did 200 deals that year. I don't remember what I said. Even simple notes, correspondence, documenting things, and I realize practically speaking, you can't document everything in a formal letter. A simple email, okay? If it's a particularly difficult or controversial issue where you've struggled with the client, take more notes to document that. Notes can be a lifesaver further on down the road in terms of helping you remember or being a record of what contemporaneously happened at that point of time in the file. And remember, clients will always remember the good news. The better resolution, the faster resolution, the cheaper resolution. You give them a range on what it's going to cost for a litigation matter, they're going to remember the lower number, not the higher number. So please take notes, please document things. It can be a lifesaver. As soon as I report the claim, I need to report the or pay a deductible. No, 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 please say it after me. You don't have to pay a deductible when you report a claim. You only pay a deductible further to a judgment, settlement, and/or repair, i.e. where there is an indemnity payment out because there was error or negligence, or as we're presuming and there are defense costs, you would pay it half when the defense is filed and half when discoveries, examinations, or pre-trials commence. So want to make that clear. Calling us up to talk to us about a claim does not trigger the deductible. There may be no deductible or no claim surcharge levy in the event we take the tack that this is really a loss prevention matter. And this is something that almost no other insurance company will do, okay? If there's an allegation of an error, but we really don't think that an error was made, we will uphold your position, including appointing counsel to take steps to defend that matter. And probably the best example here is bringing a summary judgment motion to dismiss a claim. If we do that, we will, in that circumstance, we will call that loss prevention, absolutely no triggering of a deductible or a claim surcharge levy, okay? An example of a repair in this situation is where, probably the most common one is administrative dismissal matter where an error was made clearly, but we go in and thanks to the work of our counsel, we get it fixed and the claim can continue. In that case, we would call that a repair. There would be a deductible and a claim surcharge levy in that mistake. But we do a lot of loss prevention work, and probably one of the most common areas we do that is when will files are asked to be produced. And I mentioned that example previously. Here's some more information that should give you confidence. 50% of our claims are settled without any costs whatsoever. Okay, so these are the unhappy clients, the fee disputes, the kind of the I'm reporting out of a sense of caution kind of thing. About 36% are closed with defense counsel payments only, so this is where some work was done, maybe some coverage kinds of things. About 14% of the claims we handle ultimately involve an indemnity payment, a small proportion of the overall claims that we handle there. So even more evidence, call us up, please talk to us. Odds are we can help you out with a claim. Next up, mandatory policy coverage. Is it enough or not? And again, reminder, that depends on the nature of your practice. The primary policy is $1 million per claim, $2 million in the aggregate. And by point of context, we see about 275 claims in a typical year that go over 100,000. In a typical year, we would see fewer than 10 that would breach the 1 million limit. And some years it's lower, some years it might go higher than 10. Again, when you're handling just under 3,000 new claims a year. That's a really interesting number. There are relatively few really large files. It wouldn't be fair to everyone to crank up the limits and increase the premiums because the vast majority of claims are under the current limit. And getting excess insurance is very inexpensive. Let me talk about that. And this is a little LawPro advertorial, if I can be so shameless. We have an amazing excess program. It's designed for law firms under 50 lawyers. We have 3,800 roughly lawyers at about 1,500 firms. The limits rise as high as $9 million, in excess of that $1 million limit on the primary policy. On our excess policy, the firm is the name insured, so we issue this policy and underrate it on a firm basis. We look collectively at the claims risk for everyone. No broker's commission if you get it from us. That shaves 20%, give or take, off the cost of the insurance relative to getting the same coverage from a commercial provider. And we have a retention rate of 98% on the insureds that we bring into this program. We do underwrite. We don't accept everyone. We look at your claims history, but I think it's a fantastic program. It also means in the event you have a claim, you call us up, you report one claim, it's all easy. Everything is done. If you've got a separate commercial excess carrier, you've got 2 reports and dealing with 2 returns and questions of gaps in coverage at all. Take a look at this excess coverage if you think you have exposure. There's a self-assessment tool on our website that can help you answer that question. I think all of you will find that it's surprisingly cheap. If you're thinking that the cost may be an issue, you should at least explore it for that extra comfort. When I'm retiring, I won't be insured if mistakes are found out later. Okay. Under the LawPro program, from day one, automatically, when you leave practice, you get $250,000 lifetime free runoff coverage. That is amazing. You would not get that from any other commercial carrier. Our friends in the US, where there's only 2 states with mandatory insurance programs, they have to go afterwards and get a separate policy to deal with this when they're switching from one firm to another. New firms are going to say, we don't want to be on the hook for your prior work. You're going to have to go out personally and get an insurance policy that covers your prior work. So that's a huge benefit. If you think you've got more than $250,000 in risk, if you've done big wills matters or big real estate matters, you can runoff buy-up from LawPro. You can increase it to $1 million or $500,000 extra dollars in coverage. It's extremely cheap. I had a general practice in Niagara when I practiced. I think I was paying, in round numbers when I started out, about $450 a year to take that coverage up to $1 million. Again, cheap coverage that gives you great comfort. Claims trends and numbers are reported. Let's quickly run through this. Right now, we're up just over 4,000 open claims, and this year it looks like we're going to have about 2,900 new claims at the end of the year. So a little bit alarming there, but the good news is if we look at the claims rate per 1,000 lawyers, pretty steady there, about 100 claims per 1,000 lawyers per year. So that means 10% of the lawyers in private practice and are phoning us up with claims. So that reflects the fact that the numbers of lawyers in private practice has increased over time, but the claims rate is staying the same, and the claims costs, give or take, are staying the same. They're going up and down, so that's good news. Areas of loss by cost, again, and I think you've seen this before, real estate and litigation are our biggest areas, and they kind of go up and down depending on things. Thankfully, we've come through the admin dismissal storm relatively well. We like the new rules for admin dismissals. In the background noise on admin dismissal claims, I think is actually lower now than it was before the rule change, which is good news. Over that 5 or 6 years, we spent about $15 million in admin dismissals claims. So nice to be through that bump. On real estate side, 28%. Same general trends here. Thankfully, fraud claims are down. Real estate lawyers seem a little bit more aware on the fraud front. That's good news. Claims, though, are growing in what we call the inadequate investigation or discovery of fact area, and I'll talk more about that. Wills and estates, all of the malpractice insurers are looking for that to bump up with the baby boomers and wills coming through. We are seeing that one bump up slowly, but we haven't seen the big hit yet. It still may come. Corporate and bankruptcy claims, interestingly, by count and cost, down. Why? Because we're in a good economy. When we're in a good economy, people ignore the bumps and the hiccups. They want the deal to close. So good news there. If the economy turns around, that one goes in the other direction. Causes of loss by cost. And same old news here. Communications, a little less than a third of the claims. Lawyer-client miscommunication, poor communication, no communication. That's a third of our claims, has been forever, a little bit lower now. It's also about a third of law society complaints as well. So let's focus on that communications. Inadequate investigation or discovery of fact, up to 21%. This is more than doubled from when I started at LawPro in 2001. It's actually probably close to tripling. What is this? This is where the lawyer doesn't spend enough time to get the details, to understand the client's situation, to give proper advice. So getting all the background on assets and liabilities on a wills and estates matter, getting all the details of the client's injury on a personal injury matter, okay? Today, we're all accustomed to moving faster. We've got our device, the quick question, the quick text, and so on. Clients are squeezing lawyers for time to keep the fees down. I just want a quick answer. We're seeing this error go up, and it's not a good thing. It's going to be an area of concentration for us going forward to make sure that we can try to get that back down. Time management has gone down with the errors going through. Knowledge, failure to know or apply substantive law, up to 15% from typically 10 to 12. And again, we think what's happening here is, again, lawyers are taking shortcuts because they're in a rush to keep the fees down for our clients and so on. Conflicts, good news there, long-term kind of a downwards trend. We've done loads of education on conflicts. That's great. And frauds, greater education out there on real estate fraud, greater education on the bad check frauds and so on. So we've seen, thankfully, both count and cost on that go down, but it's still an area of concern because when lawyers do get duped, those are $200,000, $300,000, $400,000 claims, can be very expensive for us. I wanted to acknowledge as well the impact that personal challenges, health, wellness, and so on types of issues. We don't always know that there's an issue in the background. If it's a lawyer with multiple claims, almost certainly there's something else going on there, but we are a big supporter of the member assistance program. We actually pay just under half the cost for it on a claims prevention and a focus or point of view. We truly believe that lawyers who can get help earlier on will help prevent claims, because when people do have meltdowns and walk away from practices, it's nightmares, there's clusters of claims, and we're frequently amazed when somebody at a law firm has a breakdown and no one else at the law firm seems to, A, have recognized that there was a problem before things crashed and burned, and people don't step up to clean up the mess after things have crashed and burned. So two things here. First of all, if you or somebody you see, you think they may be struggling, try to reach out and see if something is going on there and bump and nudge them to get help. The resources in the member assistance program go far beyond just the basic counseling and help that they used to have. There's great online education sessions, and there's now virtual counseling on a number of different issues there. If you've not checked out their resources, please do. There's some great things there. Did a drive-by shooting on an overall kind of where are claims happening. Encourage you, if you would like more information on the claims in any particular given area of law, we have our claims fact sheets that give the breakdown on the different types of errors for different specific of errors, as well as the common claims that we're seeing, and risk management advice on how to avoid claims. So I encourage you to take a look at those. Our newest resource that went up last week and is creating a great deal of excitement out there is a new chart on the changes in the Construction Lien Act. Substantial changes there, and the transition provisions, as transition provisions often are fairly confusing in terms of what the circumstances are and the timing and the different deadlines. So we've got a new resource. There's some copies on the table outside. It's available up on our website. If you do construction lien work, please take a look at it. Our concern with construction liens is many folks seem to dabble in this area every few years, and it's a really complex area where there's lots of different technicalities. If you're going to do some work, please use our chart, or better yet, talk to a construction lien person who can really show you where the bumps along the way are. Loads more resources up on our website. I commend those to you. I also commend FOLA for its support in putting a link to our resources up on the FOLA website. So thank you very much for that. I encourage you again to take a look. And lastly, I'm very, very pleased that Judah Straczynski from the Law Society has come over to LawPro and stepped into my old role as Director of Practice Pro, and looking forward to energizing Practice Pro and getting more resources out there like the construction lien chart and otherwise. And we're going to be looking to hire another person to go out and do presentations and help us prepare resources well, in particular on the technology front. In earlier days, we did a lot on the technology front, and it's more important today, so we'll look for more resources there. What I'd like from all of you, ideas. What can we do in terms of practice resources to help you practice better, help you practice more efficiently, help you avoid a malpractice claim? I would love to hear the ideas. Phone me, phone or email Ray or Judah. Get together for a coffee if you're here in town. We'd be happy to chat to get those ideas. I know in my early days running Practice Pro, it was the conversations I had out across the province after the presentations, at the dinners and so on, where people would ask questions, and I know if 4 or 5 people asked a question, that was an idea for an article or a checklist and so on. We want to collect those ideas again and build up Practice Pro. So that's the end for me. Happy to answer any questions.
I know it's relatively new that unbundled services have been out there, but from the perspective of what's going on with you, have you had any of the contracts, for example, that have been out there that will limit services for clients? Have you had any of those come up? Have you had any client complaints, and how is that all being received? Because we're trying to promote it, and I'm getting, we get a lot of concern about what you guys are going to say.
Okay, the question is, are we seeing any concerns or claims with respect to unbundled services? On average, claims come to us 2 to 3 years after the work has been done. So kind of the efforts to promote unbundled service are kind of fairly recent. It's not that unbundled services didn't happen before. We have some concerns about unbundled services because even when lawyers are handling the whole matter, there seems to be mistakes and miscommunications on what is being handled. However, we recognize, and through Practice Pro, in terms of our efforts to support lawyers in changing times, we recognize that unbundled legal services is a huge opportunity. There's loads of people out there who need help, and by providing unbundled services, it can make it far more accessible from a cost point of view. We have a page that's full of unbundled resources, checklists, retainers, and so on, that will kind of help you walk through, give the client, here's a buffet, and there's some family law documents up. Here's a buffet of the legal, the steps on a family law matter that I can help with, kind of go through and let's agree on what's there. And under the rules of conduct, you're required to have a written retainer, which is great because then it specifies the work that was done. We have not seen an increase or change in terms of claims or coming in on the unbundled services front. It may take a little time. I suspect we will see some, but there hasn't been an avalanche. Our basic advice is it's possibly a little bit more risky because the full communication isn't happening. One of the suggestions is if you've been asked to give advice on a tiny piece of a matter and you see a big limitation period issue popping up, are you obliged to raise that knot if it's outside of your retainer? And I think you probably are. But if there's a clear conversation and agreement on we can cut this in and put this in a little box, and this is a isolated step that I'm comfortable, I can provide you the advice on, there's a huge opportunity there. I commend our resources to kind of help you work through that and do it right. Any other questions? All right, thank you all.